Order, and welcome to the Northern Ireland Affairs Select Committee. This is the Surveillance of Journalists and Press Freedoms in Northern Ireland session, and I'd like to welcome our first panel, Séamus Dooley, Trevor, Birney and Barry McCaffrey. Could you please say who you are and why you're here?
Séamus Dooley, Assistant General Secretary, National Youth Journalist based in Dublin, the voice of professional journalism in Northern Ireland and indeed UK and Ireland.
Thank you. Trevor.
I'm Trevor Birney. I was the producer of a film at the centre of this case, or our case, called No Stone Unturned. I'm a journalist, producer, director of documentaries and film.
I'm Barry McCaffrey, my colleague's a member of the NUJ, journalist from Northern Ireland, and worked with Trevor on No Stone Unturned. Thank you.
Well, Trevor and Barry, can you briefly outline to us the background of your case and with the Investigatory Powers Tribunal, please?
Indeed. I mean, the story goes right back to about 2011 when Barry McCaffrey came to work at an online investigative journalism website that we had set up called The Detail. And we began to investigate the murders of 6 men in Lough Island in 1994. They had gathered in a small rural bar to watch a soccer match. On the 18th of June 1994, Ireland was playing Italy at the World Cup. And indeed, there was a very famous victory that night. But unfortunately, in the village of Lough Island, which is about 30 miles south of Belfast on the main route to to Newcastle, one of our tourist towns in Northern Ireland, 2 UVF gunmen appeared shortly after half-time in the match and shot dead 6 men and injured 5 others. Barry, whose family comes from that area, had an inherent interest in the issue and brought it to me, and we began to work on stories for The Detail, but also I was very interested in making a feature-length documentary about the case. I was working with an American Oscar-winning director, Alex Gibney at the time, who lived not far from where the game had taken place in New Jersey, and Alex and I began to work on a documentary which would become No Stone Unturned. It indeed premiered at the New York Film Festival in October 2017, and then it came back to the UK and Northern Ireland where it premiered at the London Festival. But on the day of the premiere in Belfast, the Assistant Chief Constable, Stephen Martin, released a statement saying that there would be a new investigation related to Lough Island. However, it would not be into the killers, it would not be into the massacre itself, but it would be into some of the documents that we disclosed in the film. So from that moment on, we were under a criminal investigation. Obviously, for the families, this was disturbing, to say the least, that the police were going to pour resources not into investigating and bringing those who committed that massacre to court and to justice indeed, but instead into the journalists who had worked on the film. There were documents in the film that had been sent to Barry McCaffrey and the Post. They detailed the failings in the original RUC investigation and confirmed there had been collusion between the RUC and the UVF killers. Now, 6 months before the film premiered, I went to police headquarters in Belfast and met with Stephen Martin, the Assistant Chief Constable. And I was there to advise him that our intention was to name the suspects, the chief suspects in the massacre. And Stephen Martin and I had, along with some colleagues, had about an hour-long discussion. And what we were doing as responsible journalists, we were saying, our intentions are to name these suspects. We don't know what the impact that might have on their security or their safety. We appreciate that's your role as the police force, but we wanted to give you foreknotice that that's our intentions. So we told them the names of the suspects we intended to name in the film, and indeed we did name them in the film itself. So we thought, as responsible journalists, we'd also, by the way, written to each of the suspects on 2 separate occasions to advise them, to give them a chance of right of reply, but we had received nothing back. So we went ahead and named them in the film, and as I say, the same Stephen Martin then announced on the day of the premiere that he was going to investigate the documents in the film.
Yes, so as Trevor says, we were arrested on August 31st, 2018, 7 a.m. Dozens of police officers appeared at our homes, arrest Trevor in front of his children, his 8-year-old child, Freya. We were taken away. We were brought to the terrorist suite in Musgrave Street in the centre of Belfast, and we were questioned about, I think the first accusation or allegation against us was theft, possession of stolen documents, breach of the Official Secrets Act. So we were stripped. We had our DNA taken, our fingerprints photographed. You're stripped naked. You're placed in a police cell. It was during that time that our lawyers went to court and launched a judicial review, and that really was our our saving grace, because the then Lord Chief Justice Sir Declan Morgan, he ordered the police not to examine the computers, the notebooks, or what they had downloaded from our central server until the judicial review had been heard. When it was heard a year later, we won on all points. The most senior judges in Northern Ireland made it quite clear in their judgment that we had done nothing wrong. The PSNI were ordered to hand back the materials seized, and the Chief Constable announced that he was no longer continuing the investigation into us. We were subsequently received a public apology from the then Chief Constable, and were awarded significant damages. Following the judicial review, we made a complaint to the IPT. This arose out of us coming across evidence of a covert operation being in place against us prior to our arrest. We wanted to establish if that operation was lawful. The IPT, we launched the complaint in 2019. It wasn't until 4 years later, in March 2023, that the IPT finally came back to us and said, we have been looking at your case or investigating your case for a number of years in secret court with the PSNI, and they informed us that there were issues that they had identified of unlawful activity that the police were carrying out. We initially thought that our complaint was really to do with Lough Island, so we thought that if the IPT was going to tell us anything, that it would be to do with Lough Island. But what they actually told us in March 2023 was there had been a previous unlawful interception, or the police had gone after my phone data in 2013. The PSNI we subsequently found out through the IPT that the PSNI had also harvested my communications data in 2008, 2009, 2011, 2013, and then 2018. It is important to point out here that the 2013 surveillance of myself was nothing to do with national security. It was nothing to do with legacy issues in Northern Ireland. But it was connected to an allegation that a senior PSNI employee had received unlawful payments from a recruitment agency in exchange for the awarding of a multi-million-pound employment contract, which saw hundreds of PSNI officers benefiting from lucrative pensions, only to be re-employed again to the same jobs within days. So my contact with the police press office wasn't to do, as I say, wasn't to do with terrorism, wasn't to do with the controversial legacy issues. It was to do with an issue that a journalist in Manchester or Glasgow or Wales could have been speaking to their own police, local police force. Through the disclosure that we received at the IPT, we now know that the PSNI spied on myself and other journalists solely to identify our journalistic sources. When you look at the disclosure and the police notes that the IPT has shared with us, it is quite clear that in each and every occasion, it's nothing to do with national security. It's all to do with trying to identify journalistic sources. Indeed, the documents show the PSNI branded myself and other journalists as criminals. It's down in black and white. They treated us, they said, Barry McCaffrey is a criminal. Vincent Kearney is a criminal. For what? For phoning the police press office? We now know that the PSNI, as I say, spied on me 5 times to identify journalistic sources. These included spying on my contact with trade union officials, civil servants. They even used a loyalist death threat against me to go after my phone records. And this was just an excuse to trawl through the phone records or the phones of a working journalist. That's all it was.
Yeah, we pulled a thread in making a complaint to the IPT, the Investigatory Powers Tribunal that sits in the High Court here in London. And that thread then ultimately revealed a very ugly picture of very widespread dragnet surveillance by police in Belfast. But it isn't just about ultimately the case was heard over 5 days in October last year, and the PSNI admitted and put its hand up and retrospectively said it was acting unlawfully in the spying against Barry and lifting his communications data. But in its ruling that was delivered just before Christmas, the IPT saved its greatest criticism for Sir George Hamilton, who was the PSNI Chief Constable on the day of our arrest, because on the day of arrest in August 2018, he had signed off on what's called a directed surveillance authority, not against us, but against a senior press officer in the Police Ombudsman's office in Belfast, who the police investigation had reached the conclusion that he was a suspect that had handed over secret documents to Barry McCaffrey. And we don't believe that to be true. Let's just say that be on the record. But Sir George signed off on a directed surveillance authority against that press officer so that for 3 months police could follow him, watch him, his actions, monitor his phone calls, and basically put him under 24-hour surveillance. The IPT found that Sir George had not informed himself properly in signing that directed surveillance authority, and in fact had acted unlawfully. And really what he'd done is he had decided that he couldn't put the directed surveillance against myself and Barry, so instead he would try to set a trap where he would put the surveillance on the press officer and hope that we would meet in some cafe and police officers would jump out from behind hedges or something and capture us all passing over secret documents and arrest us all. So the IPT found that Sir George had acted unlawfully, and we were again awarded damages for that particular problem or that particular finding. This is like a storyline from Line of Duty or some sort of Kafkaesque type novel. What we discovered in the thousands of pages of disclosure is that the PSNI was seeking the support of the Metropolitan Police going back as far as 2011 in order to surveil the communications data of journalists in Northern Ireland. At one 4-month period in 2011, over 4,000 phone calls and text messages were monitored by the Met at the behest of the PSNI. Many of those phone calls and messages were between BBC journalists, and we'll come on to that. But basically a UK police force was spying on the state broadcast of the BBC and its journalists and sharing that unlawful surveillance data with at least 2 other UK police forces, PSNI and Durham Constabulary, who also were involved in our arrest. So the Met has admitted that its actions were unlawful. But today, as we sit here, we now have what's called the McCullough Review. Angus McCullough, a very eminent KC based in London, has been brought in by John Boucher, the PSNI Chief Constable, to conduct a review of everything that come out of the IPT. We don't believe that review goes far enough. We think the remit is far too narrow, and we think that Angus McCullough, despite being a very, very experienced and knowledgeable KC, basically doesn't have the tools to get to the bottom of what's going on here. And we think that this also isn't an issue that is just relating to Northern Ireland. I think it relates to all areas in the UK. And indeed, David Davis MP, who is here today and has supported us throughout the case, was so concerned by what he had learnt in the IPT. He wrote to all police forces in the UK to say, have you been doing the same thing as the PSNI has been doing? Just can you be clear about... But as David said, he got what he described as a dead bat response from all the police forces, basically saying nothing. And that is very concerning. So there obviously raises suspicions about exactly what's going on right across the UK, not only in Belfast.
Thank you, Trevor. We will be awaiting the review. So I'm going to go to Gavin Robinson.
Thank you very much, Chair. Good morning, gentlemen. Séamus, do you mind if I come to you first and ask you a question drawing on the comments of your General Secretary immediately after, where she indicated that the IPT process couldn't be the end and that there remained questions that were unanswered?
Yeah.
Could you give us a sense of, from her perspective or your union's perspective, what those questions that remain unanswered are?
Well, I think Trevor and Barry in many respects have answered that, and first I want to acknowledge that no journalist seeks to make headlines or to be the story, and Trevor and Barry never set out to be the story, nor should they have to spend so much time of their career exposing this. And from our perspective, I think Northern Ireland has always, to use the words of David Trimble, it's been a cold place for journalists. It's been a cold place. The shadow of of Martin O'Hagan lingers over journalism every day in Northern Ireland. What we have seen here is a systematic treatment of journalists as being the enemy. That journalists are criminal, and that any activity which seeks to shine a light, which is the function of journalists, is automatically viewed to be a crime. And so it is the mindset, Mr. Robinson, which is the problem here. The issue around who else was, the question of how many more people have been under surveillance. And it's not just journalists. The fundamental issue with the concept that the right to be represented by lawyers is undermined by surveillance of lawyers. The word that kept coming back to me as I sat in the IPT was contempt. Contempt for journalists, contempt for lawyers, contempt for due process. In terms of what we want next step, I declare an interest here in that the Chief Constable established a review group, the McCullough Review, and an advisory panel which includes the NUJ, represented by myself, Baroness O'Loan, Amnesty, Committee for the Administration of Justice. And we are an expert group and shareholders or stakeholders who advise McCullough but not part of the investigation. I agree that that is a limited investigation. I think it will be useful. I think it deserves a fair wind, but it does not address all of the issues. The key issue is, and I think this is the important bit here, is that this is about the wider treatment of journalists, and it is not just Northern Ireland based. And while this is the Northern Ireland Committee, it is concerned to every Member of Parliament.
Thank you, Séamus. We have agreed to publish a letter this morning from the Chief Constable on this issue, and he talks about the number of applications for data that were made during the period between 2011 and 2024. Of that, he indicates 0.5% were toward journalists. It's 0.5%. Mr. Birney, can I ask you what your view is on the response of PSNI following the judgment of IPT?
Well, as we've said, Gavin, we welcome the McCullough review. We believe it's a first step, and we met with Angus McCullough last week, and we were very impressed by his determination to excavate as much information as possible. However, we think that only a public inquiry, a wide-ranging judicial-led public inquiry, will really get to the bottom of all of this. One of the fundamental issues we have with the review that Angus is conducting is that for arbitrary reasons, it starts in 2011. It only covers the period from 2011 to 2024. But what we learned at the IPT in Barry's case is that there was at least one issue in 2008 where Barry's phone data was lifted. And let's just be clear, when police harvest communications data, all of you will know that you all have communications with journalists. You all speak to journalists on a daily basis. That information is now in the hands of PSNI. The PSNI know what journalists are speaking to what politicians. And we feel that is an attack on democracy. We feel that is an attack on the protection of journalists and their sources. So I think this isn't just an issue that pertains to the journalistic community. We feel that it's for, whether it's politicians, lawyers, activists and journalists, we feel it's a much broader societal issue, and that's why there needs a public inquiry. But
just to be clear on that, there are principles around the surveillance of MPs and so on, but what you're highlighting is the incidental contact.
Yeah.
So it is, there have been other examples.
I wouldn't say it's incidental, but yeah.
No, but the direct application is not relating to the individual that is then contacted by the person being surveilled. But there have been discussions around, for example, within another media outlet in Belfast, 16 of their journalists being subject to surveillance, and in actual fact, they were probably incidental to the one person who was being surveilled, but that one person was in contact with each of those, and it's the picture that paints and the data that's then gleaned from that. That's the point you're making?
Yeah, I know, but yes. And but I know from your own party that no.
I'm not saying that incidental is inconsequential.
Yes, exactly.
It's not the subject of
exactly. You know, and I think that for the McCullough Review, it obviously starts in 2011, but for us, we think it should go right back much further. The first Chief Constable of the PSNI was Sir Ronnie Flanagan. He was succeeded by a gentleman called Hugh Ord. And Hugh Ord joined the PSNI in 2002 when there were political difficult times in Northern Ireland. And he had a difficulty because he was concerned that officers were speaking to the press outside of the press office control, and that there was informal contact, particularly between members of the special branch and journalists. And Hugh Ord introduced a policy that it was a sackable offence essentially to talk to a journalist without an agreement from himself or senior officers. And that was there to try to stop leaks from within the PSNI at the time to journalists. And there was one senior special branch officer who had to leave the force after he spoke to a BBC journalist in a very notable case. And we think that what happened is Hugh Ord put in place a defensive operation, what he thought was a defensive operation at that time, and that is basically to say to all police officers, if you speak to journalists without authority, you can get sacked. And I think that Sir Hugh had come from the Metropolitan Police, and we think that he brought that playbook with him from the Metropolitan Police, and he introduced it in the PSNI. And we feel what happened since then is that defensive operation, quote unquote, has been described by the PSNI, has become an offensive operation. It has been used against journalists to find out. So when Barry McCaffrey called in 2013 on a Monday morning to the PSNI press office and said, "Are you investigating an allegation of corruption?" That was a simple question. Are you investigating an allegation of corruption? Within 48 hours, Barry McCaffrey was turned into a criminal suspect. There is documentation that we've seen. Barry McCaffrey is a criminal suspect. He's mixing with other criminal suspects. We now need to lift 3 weeks of his incoming calls and outgoing calls to find out who the source of that. Now, indeed, it was a DUP member of the policing board that raised concerns about that corruption. And what we had discovered that he was concerned that the PSNI had not been clear with them. Yeah. So that's involving an elected member of the Assembly in Northern Ireland who was raising concerns. But the PSNI turned Barry McCaffrey into a criminal suspect, and we feel that defensive operation was an offensive operation, that when any journalist calls a press office, they're turned into a criminal suspect to find out who their sources are. Now, you've got to ask yourself why that has happened, how that has happened, and that's why we think, obviously, a public inquiry, we really can get in under the bonnet and to get to grips with the culture that led to that suspicious activity.
Let me just ask you, and I don't mind Mr. Birney or Mr. McCaffrey whether you wish to answer this question, but we will unpack some of the other issues in the rest of this session. You've referred to correspondence from our colleague Mr. Davis to forces throughout the United Kingdom, and we've been operating, and some of this relates to legislation 25 years ago in RIPA, Regulation of Investigatory Powers Act, and then there's been subsequent legislation since. But from your experience, in the absence of a conclusion to McCullough review, and indeed whether there be further inquiries, what legislative steps or changes do you think need to be made by this Parliament to ensure that the type of surveillance you have experienced are not repeated?
Well, I think what is in place, but what has been abused, is the judicial oversight. You know, there is a guidelines as to what the police should and shouldn't do, what is lawful and what is unlawful. The judiciary is the proper process to ensure that the police, if they're surveilling journalists or whoever else it is, that it is a lawful act. What the police have done time and time again is they have tried to bypass the judiciary. They have abused the system. So, in answer to your question, the police need to be held to account to follow the rules, because it wasn't us who broke the law. It wasn't, confidence in policing has been seriously undermined and damaged. Trevor didn't do it, Séamus didn't do it, I didn't do it. It was the PSNI.
I don't want to put words in your mouth, but
yes.
Does that suggest that the law as it stands is right,
well,
but it wasn't followed, as opposed to suggesting there are changes required within the law?
Well, I believe that those the current legislation needs to be strengthened. It needs to be further strengthened, because as it stands, the PSNI is ignoring it. So something has to, as Trevor says. Go ahead, Trevor.
I think the law is there. I think it's quite interesting that journalists are treated as criminals. Criminals are people who break the law. This practice of breaking the law and looking for a sort of forgiveness afterwards is not acceptable. The culture will only change when there are consequences for those who break the law, and that includes members of police forces who do not adhere to the rule of law. It is completely contradictory that those who are entrusted with protecting citizens abuse and break the law without consequence. The NUJ has always opposed the IPT. It was a very useful exercise. It has, to borrow from Trevor's metaphor, is the classic thing of what a tangled web we weave. And there was a practice to deceive. But the reality is that the IPT process itself is a secretive process. It's a sort of a mysterious body. It has been useful. But even the title, it was established to deal with terrorist offences. And the only way we can get the truth about the treatment of journalists is through going to the IPT. There's something really rotten about that.
Thank you, Mr. Lee.
The constant, the constant in this is that there have been various legislative changes over the period of time. We're talking about a 20-year period here, and there's been various changes to the legislation in RIPA and GRIPA and the IPA. But what we've seen, the one constant is, right up to 2018, is an attempt to get around that legislation in place. That's what the IPT found when St George Hamilton signed off on the DSA, that he either didn't inform himself properly or indeed ignored the legislation framework in which he should be working in when he did that.
And whilst this session is focused rightly on PSNI, we had to mount a rebellion a number of years ago around the extension of these powers to groups as far-ranging as the Food Standards Agency. Just to be clear, it's not just the police.
Yes, sorry, Captain, just to come back in with you. We found out that in 2011, the Met is intercepted 4,000 text messages and phone calls of journalists in Northern Ireland. There is no police investigation into... the Met were found to have acted unlawfully by the IPT in that case. There is no police investigation into what the Met done. The Met was spying on the national broadcaster, and nobody is investigating it. Nobody is questioning how and why this was allowed to happen. The courts can only look at individual cases. In our case, it was very restricted in what it could find. It's only Parliament, it's yourselves, and a public inquiry that can deal with policing policy, its operations, and the attacks on press freedom.
Thank you.
Sorry, thank you,
Chair.
Chair.
Adam Georgie.
Thank you very much, Chair, and thank you for being here. Thank you for bringing the sun with you, which I think is a very apt reflection of the, well, indeed, shine a light on these very important issues. So that's an important bit of symbolism, Trevor, that no doubt will feature in one of your films before too long. I also want to thank you for your opening remarks and the thorough setting out of the experiences you've been through personally, the impact on your family, and more generally your profession for simply doing your job. So thank you very much for doing that. I have a simple question in relation to the Policing Board and the PSNI report that was issued in June 2024 alongside the McCullough Review. And the Chief Constable published this report to the Policing Board on the use of covert powers by the force. And I want to know if you can give us a flavour of your observations and thoughts on that report.
No, okay.
Well, we welcomed the sort of the transparency in John Boucher's report and what he said, but obviously it leaves a lot of questions unanswered. Obviously, there were very significant figures around journalists, 300 incidents involving journalists, over 500 involving lawyers. And that's what Angus McCullough is obviously hoping right now to bring further light to what lies behind those figures and what those incidents were about. So I think that John Boucher has tried to respond to the public concern of the disclosures from the IPT, and I think that the document was incredibly detailed and an important contribution. But again, I don't think that it does answer all the questions. I think that John Boucher has to wait until Angus McCullough delivers his report. He's got a responsibility in ensuring that Angus McCullough gets access to every file and every record within the PSNI, and that there is no obfuscation or delay, that there is no attempt to prevent Angus McCullough from getting information that he requests. Now, we understand that John Boucher has ensured and assured Angus McCullough that he will, but we feel obviously without the ability to compel witnesses and to compel documents, that we've got to trust the PSNI. But if you'd been a witness to our cases at the Judicial Review at the High Court in Belfast in front of the Lord Chief Justice, the then Lord Chief Justice, or at the IPT over the course of the last couple of years, you would have seen an incredible amount of delay, obfuscation and denial by the PSNI in those cases. Really, they had to be brought to the courts kicking and screaming, and they didn't hand over the disclosure. In fact, it was Durham Police Force who they had brought in to investigate myself and Barry. It was Durham that delivered the most important disclosure in that case, which much of it was PSNI files, but the PSNI hadn't delivered it, hadn't disclosed it. It was Durham that did that in the IPT. So what we're saying is we're coming from an experience in which the PSNI has not been open and transparent. We welcome what John Boucher did in that report. We welcome bringing in Angus McCullough. We simply feel that you can't have somebody marking your own homework. You need an outside body, whether it's the Northern Ireland Affairs Committee, whether it's a public inquiry. You need an outside body holding the PSNI to account. Because some of the information that we found in the disclosure was, as Séamus used the word contempt, an attitude of contempt towards the police ombudsman. When the people of Northern Ireland voted for the Good Friday Agreement in 1998. Subsequent to that, there was a review of policing, and that led to the establishment of the PSNI. But it also led to the establishment of institutions of accountability. You had a police ombudsman that you could take a complaint to, and you had the policing board where you had elected representatives and members of the public sitting that hold the PSNI to account. But in the disclosure documents, we actually saw a police officer write, well, we'll only give the ombudsman the documentation that we feel is relevant. Now, that to me is a contempt for the police ombudsman and something that really concern anyone in Northern Ireland about the checks and balances within policing. The policing board, having sat throughout this period that we're talking about, clearly knew nothing about the spying operation on journalists. So you could ask yourself, what is the point of a policing board if it's not getting the information from the very organisation that's there to hold account that we're putting our trust into? So there is an issue of contempt that has been shown towards elected representatives, towards the police ombudsman's office, that plays a very critical role in Northern Ireland. So I think that's why we've gone to the space of a public inquiry, because we feel it is about the culture, it is about the contempt shown towards journalists, lawyers, activists, and indeed to our institutions of state by the PSNI.
Do either of you want to come in on this?
I would just very wholeheartedly agree with Trevor on the unacceptable manner in which information was released to the IPT. The PSNI engaged in what I would describe as a form of judicial striptease, where every day you walked in, there was a new little piece presented. In a way that I'm an experienced journalist, an editor and court reporter, I have never seen evidence presented in that absurd manner. And I believe that the McCullough Review is a worthwhile exercise. I think it will be useful. I think it will form the basis for further investigation. But I would not underestimate the difficult task of restoring confidence in a system which has been shattered by the behaviour revealed at the IPT.
Yeah. I can tell you're a man of the spoken and written word, Séamus. Judicial striptease is one that has now been written into the books twice over. Thank you.
The only thing I can add is what probably angers us the most is the whispering campaign that some within the PSNI are continuing right until this very day against Trevor and myself and against journalists in particular. When we were first arrested, someone within the PSNI leadership was briefing that anybody who supported us, whether it was the Irish government or political parties or trade unions, that they would be left with egg on their face. This was the phrase that we kept on hearing again and again when we were meeting different parties and different organisations. The PSNI have told us, if we support you or if we support press freedom, we'll be left with egg on our face because there's some other motive going on here. And we're hearing the same thing again. 8 years later, the PSNI have a whispering campaign going on. They're only telling half-truths. And that's, to me, that's sad because we have confidence in John Boucher. We believe he is a decent and honourable man. But the PSNI have to take a decision. Either they dig this, they keep on digging this hole, that they're getting themselves into this, this mire of just, as Trevor says, obfuscation and just withholding and a total disrespect for democracy. John Boucher has to decide today, this has to stop. This has to stop. Journalists aren't criminals.
Can I just ask one follow-up question? Trevor, you said that the initial report from June 24 left more questions unanswered than answered. Can you just give us a flavour of what those key questions would be? I mean, you've touched on it, but just give us a clearer set of... because that helps influence how we respond in shape.
Yeah, I think that ultimately, I think Angus McCullough would agree that it was an arbitrary decision to set 2011 as the start date for his review. We feel that isn't going to get to the bottom of where the spying operation emanated from, who ordered it, why, and where did indeed the culture that led to the incidents that we've seen at the IPT involving Barry and myself, where did all that start from? So I think that the 2011 date will not give us the answers to those questions, and we want to know what happened prior to 2011. The other key question is about the role of other institutions of the state outside the PSNI, because the McCullough Review could only look at the actions of the PSNI. And so there was a morning at the hearing in the IPT in October when we discovered during disclosure that a BBC journalist, a then BBC journalist called Vincent Kearney, had also been subject to surveillance at the same time as Barry McCaffrey back in 2011. And the BBC had applied to join with us and for that case to be heard at the same time. Now, what happened is that there then was an intervention on behalf of the security services, MI5, GCHQ, by a barrister. And he told the court that MI5 would need a number of months to unearth the documentation that it had relating to BBC journalists in Belfast, and that they were going to need to hire a team of barristers. They're going to need to be security vetted just to examine the documentation. Now, the indication to the court obviously was that there was an enormous amount of information that MI5 held on the BBC and its journalists. And MI5 asked the court to remove the BBC from our case while it continued its research. And the IPT agreed to that request. Now, what I think the questions that are raised from that particular part of our case is, what is the relationship between MI5 and the BBC? What do BBC journalists know about that relationship? And how much data and information are MI5 getting access to with BBC journalists who are obviously working in very sensitive areas, dealing with very sensitive issues, and talking to individuals from right across the spectrum, not only in Northern Ireland, but right around the UK and indeed the world. So I think that is another question. Unfortunately, the McCullough Review cannot give us answers to that. What is the role of the Met? What is the role of MI5 and GCHQ? What are they doing in terms of journalism and lawyers and activists and others? So those questions are fundamental. I think the other question Barry can probably address is the issue of intercepts, and that's not going to be dealt with by the McCullough Review.
Yes, so as we understand, I think we're correct, that intercepts are when police surveillance it's alive, it's an ongoing at the minute issue. So police can read your emails, can read your phone messages, can listen in on your calls. Angus McCullough can't investigate intercepts. He can't make any public statement on intercepts. So it's it's an important part, we would say, of his review on our journalists being spied on a daily basis, or their phone calls being listening to. The McCullough Review can't tell us that. Even if it was to say no, it's not happening, he can't say that, and we believe that is a major black hole in the review through no fault of Mr. McCullough himself. It's the terms of reference.
Yeah. And Adam, going back to I think Gavin was touching on as well, a lot of what we found at the IPT was simply the police were able to see who journalists were speaking to, that there was a phone call between myself and Barry, or there was a phone call between Barry and a BBC journalist. They were able to see that, or all Barry's phone records. What they weren't doing that we didn't see any evidence of at the IPT was listening to what was being said in those calls, or indeed where they weren't looking at emails or weren't looking at text message or WhatsApp message. We didn't see any evidence of that at the IPT. But even if they were doing that and it was lawful, we wouldn't have been told about it. If it was under the legislative framework of the PSNI, were following the letter of the law, and we're listening to phone calls, we wouldn't be told about that. And I think we should be told if indeed those type of intercepts are happening. And I think that for the Boucher review or the McCullough review, it won't go into that territory. And we think we need to go into that territory. We need to know, are indeed phone calls between journalists and the sources being intercepted and being listened to for whatever reason. And because I think that's about protection of sources. And I think that is a very important foundation pillar in our society, is that the protection of sources, and that's in the NUJ code. And I think we've all benefited from that in the UK. So I think that what we've got to be sure is that any source that feels, today many of my phone calls start with, is it safe to speak with you? Can I talk to you privately without having any concern that somebody is listening to this? And I really can't give any source the guarantee that indeed the police aren't listening, having come through the experience of the last few years. And I think that's something that journalists throughout the UK have got to remove, that burden. They can't have a burden on them that when they speak to a source that they're being listened to or their data has been intercepted.
When we call out that behaviour overseas,
Indeed.
Yes.
Yeah. Indeed.
And I just said that on that, I mean, the right to protect source is fundamental to the practice of journalism. But the right of so many professions to practice is based on trust. If a lawyer cannot speak to a client because they may be under surveillance, if a politician may be placed under surveillance, that presents a fundamental problem for democracy. And not only is the threat, the very possibility of a threat being compromised inhibits the practice of journalism and is bad for democracy.
Thank you.
Journalism has enough problems today.
Trevor, I know that you've referred to a case which is before the tribunal, but it is not sub judice, so that's... but just to tell you that as members we are exercising discretion during this session. Okay, Katrina Murray.
Yep. And again, gentlemen, thanks very much for coming in, and I think you've probably addressed some of what I'm going to be asking. In my life before here, I spent a lot of time training new trade union stewards, and one of the things that we always taught them about was data. How do you make sure you use the data, and particularly when you're using an employer system, you're making sure that even though there was data sharing agreements in place, that actually there could be a route for employers to be accessing that, so you would be careful to do that. One of the justifications that the PSNI had used in the 2014 report for accessing communication data relating to journalists was the suspicion that it was police officers and police staff that were the sources. Therefore, they were potentially looking at. I accept very much the position that is there from the NUJ code. What would your response be to that justification from the
thank
the
you,
PSNI?
Katrina. Yeah, so as Trevor said, this defensive operation was in place, and on face value, that's great. It's if a police officer is acting unlawfully or doing something that's wrong, leaking information to a journalist, yes, that's wrong. In our experience, what we have found from the IPT, so the Met, as Trevor said, in 2011, on behalf of the PSNI, had intercepted 4,000 phone calls and text messages belonging to 16 journalists. When we looked at that data, it wasn't a call from a police officer to a journalist. It was a call from a journalist to a journalist. 4,000 text messages, 4,000 phone calls. It was journalist to journalist. That's not a defensive operation, that's an offensive operation. That's spying on journalists to identify their sources. So, as we said, the police said, and maybe when the defensive operation was initially set up, maybe they did play by the rules. But by 2011, they were breaking the rules on an industrial stage, on an industrial basis. 4,000, that's not just, an accident. Accidents don't happen 4,000 times. So, no, we don't believe that the defensive operation was to identify police officers, rogue police officers. It was to identify journalists and their sources.
Could I just say that if the problem is so great that you have to have that many rogue police officers, the issue may be one of training and discipline within the force rather than a problem with journalism. The reality is that this issue of what's sometimes called incidental surveillance, or almost like collateral surveillance, is a problem which organisations like the NUJ and Liberty have identified, not just in Northern Ireland. This is a problem throughout the UK. It just beggars belief that we can take this seriously. If you ring, look what we're talking about here. You know that a press officer is going to talk to journalists. This is, it happens, and therefore, if you put a press officer in surveillance, well, if they're not getting calls from journalists, they probably shouldn't be press officers.
Thank you very much, and thank you for your evidence. And I know people will find a lot of this alarming, but it is important to resolve for the culture of lawfulness and trust that we're trying to create. A lot of what this committee is going to be doing in this mandate is looking at issues relating to suppression of information about the legacy of the conflict. Do you think that there was a culture within the PSNI about suppressing information about failings during the conflict, and that is something that has bled into operations relating to everyday and current day policing?
If we take no stone unturned as evidence or a case in point, the families of those who died in June 1994 obviously wanted to see justice for the death of their loved ones, and they put the full faith in the RUC that they were indeed going to leave no stone unturned in bringing the perpetrators to justice. But year after year after year, those promises and commitments fell short, obviously, and the families grew more and more frustrated at not seeing somebody being held to account for the murders of their loved ones. The families ultimately turned to the police ombudsman and made a complaint in 2006 and simply said, could you tell us why the killers are not in prison? And ombudsman investigation began. One report was delivered in 2011 that wasn't found to stand up, and it was withdrawn. And then Dr. Michael Maguire, who had been with the Criminal Justice Inspectorate previously, was appointed as the Ombudsman for Northern Ireland. And Dr. Maguire began a new investigation into the Loughlin Island massacre. In June 2016, he delivered his findings and found that collusion was a feature of the Loughlin Island massacre. And that meant that the RUC had colluded with the UVF to basically ensure that no one went to prison after the incident. So he delivered that report. Some retired police officers in Northern Ireland took great umbrage at his findings and went to court in order to try to overturn or have indeed Mr. Maguire's report thrown out. That failed. We were then working on the documentary in parallel to those legal cases that were being heard. And it's quite clear that when the retired police officers failed to have the Maguire report thrown out, that happened in parallel to the decision to arrest myself and Barry. In April 2018, we can see the genesis of the operation to arrest us. We can see in disclosure documents, documents were being exchanged to say we want to arrest them. And they began to put the structures in place. So it wasn't that it was, as John Boucher has said, a fast-moving situation on the day of our arrest in which decisions were being made. It was very meticulously planned. And we feel that what was going on there was a further attempt by the PSNI to really undermine the Ombudsman and undermine the report of the Ombudsman by getting in to our offices, get into our homes and attempting to try to find information or evidence that somehow it could link us to the Ombudsman. So we feel our arrest was a direct assault on the office that has been an institution of accountability in Northern Ireland. We feel that the PSNI were really trying to prevent Michael Maguire and the Ombudsman from bringing forward further reports into collusion, allegations of collusion in Northern Ireland. We feel that there was an attempt to try to stymie, frustrate the Ombudsman, who obviously was, his office was, as we now know, a focus of the investigation as well. So here you have an institution of the state that's set up to hold the police force to account, and the police force putting that institution under investigation and putting directed surveillance onto a press officer who works for that institution. Can you understand the significance of that if that would happen in any other part of the UK? And I think that is really all to do with legacy in Northern Ireland and all to do with those who are out there who are trying to deny the history in Northern Ireland and also trying to protect a dominant narrative that in Northern Ireland that we feel no stone unturned challenged.
I note your comments of some confidence in John Boucher's fresh approach to some and some of the processes that have still to run. Obviously, the policing board was a big part of the new beginning to policing and the change that needed to be created. How would you assess? Do you think they have been robust enough in their, I suppose, accountability role on these issues?
It's difficult to say, but unfortunately, who is to blame? Is it because the PSNI is showing utter disrespect to the policing board and utter contempt for it, or is it that the members of the policing board aren't holding them to account? The policing board, its raison d'etre is to hold the PSNI to account. That's not happening. That's not now. Who is to blame? Can't John Boucher change that culture to turn it round, to turn this big juggernaut round, to see that for the PSNI to see that the policing board isn't the enemy, the police ombudsman isn't the enemy, lawyers aren't the enemy, and journalists aren't the enemy. As Trevor says, as part of the disclosure, we see a policeman writing in his notes, we only tell the police ombudsman what we want them to know. We believe the same thing is happening with the policing board. That key information is being withheld from the policing board, and to be honest, that the PSNI isn't being truthful. As Trevor says, for 8 years we've had to drag them kicking and screaming into court. We've had to drag every morsel of truth. They have fought against it. And we believe that the policing board is victim to that same obfuscation.
You've touched on it, whether or not, do you feel that there is enough accountability and oversight for other police? I mean, we have the policing board, imperfect though it may be. Is there enough accountability mechanism on some of the other forces involved in this?
If they are properly operational and the PSNI is being transparent and being held to account and allows itself to be held to account, then indeed we have very strong structures in the policing board and the Ombudsman's office, but I think both of them need to be allowed to get on to their job, and the PSNI has got to understand the relationship that it has with those institutions and the importance of actually the public having faith that those institutions are getting questions answered. And I think that our experience is that this operation has been going on for many, many years, and it seems that only the policing board is only waking up to what actually is went on. We saw after the judicial review the appearance of Sir George Hamilton and his counterpart from Durham Constabulary, and we saw an open session, the policing board asking questions of the two chief constable. And really, if that was accountability, it really was quite shocking. It was, in our mind, a real failure to appreciate just the severity and the significance of what had happened at the judicial review. And I think that is it's worth watching back that appearance by those two officers, because it felt as if it was a day out and nothing to be too worried about.
Yeah, could I just, on that, say that, I mean, the distinct lack of humility or any failure to understand what had happened at the IPT was stunning. So you talk about, in that sense, it's new beginnings, but it's the same old story. And I think, the phrase that culture eats strategy for breakfast comes to mind. One person, I think the danger in believing that one person, even a chief constable who clearly in my view is on the right thing, cannot change a culture. At the heart of this is the priority which has been consistently given to putting journalists and people who are asking awkward questions, giving that a priority rather than the core function of policing, which is actually to solve crime. The priority given to an investigation into the work of journalists rather than into the very scandal which led to the work of the journalists in the first place.
Finally, for me, because I'm aware that the time pressure, you obviously won your judicial review against the seizing and the raiding on your data. What's the status of that data at the moment, and has that been vindicated, or does that still exist within the PSNI?
So there was an agreement reached with the PSNI after they advised the court that it would cost a significant amount of money to the public purse to remove the data that it had backed up on its systems in Belfast. And so it was agreed by our legal teams that the data would be, there would be a series of checks and balances to ensure that data wasn't accessed. And again, at the IPT, it's a bit of an issue now where they're dealing with the same thing. The data that was taken from Barry's phone on numerous occasions is still backed up on the PSNI systems, and so the court is trying to resolve that. That's a very live issue. So yeah, it is clear that the PSNI have something of a historic system. It hasn't updated its systems in Belfast, and it was going to cost a significant amount of money to allow it to have a more flexible system, so that in cases like ours, that it could simply go in and remove the data and dump it, or go up onto the cloud and delete it. It can't do that because we understand it's backed up onto microfiche and it's mixed up with. That's a very rudimentary explanation of exactly what's going on, but it's, in my mind, they simply can't come in, cut a piece of tape, take it out and put it, because it could ultimately undermine the whole backup. So there is a question, I'm sure John Boucher will answer that in the future, about the need to update those systems and ensure that information that it shouldn't have is expunged from the record, and we feel that's very important for public confidence, again, that is addressed at some point in the future.
A lot of issues we'll want to come back on. Sorry, Barry.
Yes, no, just to reiterate what Trevor says. So the courts have ruled that the PSNI hold this, they unlawfully obtained this data. The courts have ordered them delete the data, and the PSNI are saying it's going to cost us £5 million. We can't do it. How many other police forces in the UK are in the same position? We don't know. Maybe there's none, but maybe there's lots. And this is data that is has been unlawfully obtained. If it was happening in a private company or any other, health department or whatever, it's not acceptable that we're being told, oh, you have to wait 10 years. Until we decide that we can get rid of this stuff. This is a major breach of GDPR and data protection, and it's being allowed to continue. It's frustrating for Trevor and myself, but our legal advice was there's nothing you can do. The courts aren't going to order them because it's going to cost so much money. So the most that we could do, or our lawyers could argue, was there had to be protections and safeguards that the PSNI weren't going to be able to access this without the court's authorisation. But it's not a practice that should be allowed to go on.
Thank you,
Just to clarify something there, just to give us sort of context around that. On the day of our arrest, the PSNI seized our phones and our laptops. Took my daughter's phones and my wife's phone. Took USB keys that had my daughter's homework on it, and then they went to our offices and they basically plugged in their computers to our server to, according to the warrants, to remove all the data relating to No Stone Unturned. But actually, the data relating to No Stone Unturned made up less than 6% of that server. The PSNI downloaded 100% of the server. So they had access to every investigation the journalists were doing, all our documentaries, all our accounts, everything. And they knew they were taking everything. They were walking past desks and taking notebooks that related, journalistic notebooks that related to stories such as clerical abuse within the Catholic Church. And they were pointed out to say, well, this has got nothing to do with No Stone Unturned. So, well, it may be of interest to it, so we're taking it. Thank you very much. So it's quite clear that they'd gone over, extended way beyond the warrants that had been granted. Those warrants were granted unlawfully, obviously. And so that information all made its way into the PSNI's hands. It was all held by the PSNI for several months. Now, after Sir George Hamilton and the judicial review decision, he handed back all the physical hardware, all the computers and laptops. Everything came back, but everything that was backed up stayed.
Can I just clarify something for 1 sec, just really briefly?
Quickly, please.
So, back in the day, whenever people's houses were raided by HMSU and others, they went through the kids' pants drawers, they went through everyone's drawers, they went through the kids' clothes, they went through the wife's clothes. Are you telling me that whenever they went in and took that data, that they took your daughter's wee information about her schoolwork?
Yes. Yeah.
The pink course.
And her wee life?
The pink course.
Yeah, they had a little pink phone, that I think my 14-year-old daughter had, a pink iPhone, and yes, they took that phone and they removed all the data from it.
I don't even know what to say to that.
Ingham.
Thank you so much for your evidence today. It's been really candid and really illuminating. I'll keep this question quite quick if that's okay, but specifically to you, Séamus, if that's all right. So in 2023, the National Action Plan for the Safety of Journalists said that the PSNI have made transformative progress in addressing journalist safety in Northern Ireland. Yet last year, Amnesty International published a report stating that journalists in Northern Ireland, particularly those investigating illegal, paramilitary or criminal activity, have been operating in a climate of fear for years, facing far too regular threats. So I wanted to know, firstly, how common threats are towards journalists in Northern Ireland and how much of it is a worry for you. And I'll do my follow-up now so then you can wrap up. What would you like to see the UK government do to ensure the safety of journalists in Northern Ireland?
I know time is short, but just to say that, threats against journalists, you'll hear that in the next session as well, are a reality in Northern Ireland. I would think that the scale of it is underestimated because it has, and one of the problems we have as a union of journalists is to convince people to report threats, because there's a generation of journalists in Northern Ireland following the death of Martin O'Hagan who actually almost think that threats are part of their professional life. So while there was an attempt, as part of the national strategy and its good campaign, there has been improved liaison with the PSNI on occasions. That's hit and miss, is how I would describe that. The reality is that there are a number of journalists who are under have received death threats. We have had a member who's a threat against not just her but against her baby. We have had situations where people's life have been threatened, and lesser threats are seen by journalists sometimes as being routine. The National Union of Journalists are very clear. We've always advised people that what they need to do is they need to report threats in all cases. In terms of what you can do, I think there are a number of, one of the areas which I think is a real concern, apart from the physical threat, is the failure of tech companies to deal with online abuse and threats. That threat, that is real, and there is a huge level of misogyny. And female journalists in particular have been the victim of it, and female politicians, by the way, as well, as you'll be aware. So it is, and I think that one of the big challenges is the issue of online abuse.
Okay, I'd like to say thank you very much, Séamus, Trevor and Barry. It's been an excellent session. We're going to stay live now and we're going to change the witnesses. So thank you very much for your time.
Thank you.
Thanks, Gail. Thanks, everybody. Thanks.
Thanks, Chair.
Excuse me, I've got a constituency thing. Thank you.
Thank you so much.
Yes, please. Thank you very much. I'd like to welcome panel 2. We have Allison Morris, Malachi O'Doherty, and online we have Paul Tweed. Just to open, could you say who you are and what your role is?
I'm Allison Morris and I am a crime and security journalist. I currently work for the Belfast Telegraph.
Malachi?
My name is Malachi O'Doherty. I'm a writer, author, freelance journalist, occasional broadcaster, commentator, and largely retired as well since I'm in my mid-70s practically now. So, but yes, that's what I do. I write books about Northern Ireland and about myself, and I write 2 weekly columns, one for the Irish Post and one for the Belfast Telegraph, and I appear frequently on radio programmes and television in Northern Ireland.
Thank you. Paul.
Good morning. My name is Paul Tweed. I'm a media lawyer. I act for claimants and defendants in the jurisdictions of the UK and Ireland. I act for numerous MPs, MLAs and TDs across the political and religious divide. I'm based primarily in Belfast, although most of my work is in Dublin, which is where the social media platforms have their European, Middle Eastern and African headquarters.
Thank you, Paul. Alison, how common are threats made by paramilitaries or others towards journalists in Northern Ireland?
In my case, very common. So there's not very many journalists actually do what I do, crime and security journalists. There wouldn't be a great deal of people who either do that or would want to do that for very good reason. People would be smarter than to want to do what I do. In the last, probably if I go back to the last 12 months, when the police deliver a threat to you and tell you they're on, and I'm taking away online threats, that's a daily occurrence. I've gone beyond even concern myself about that. But when we talk about TM1s, which are actually threats from either paramilitary groups or organised crime gangs, in the last 12 months, I think I've had either 8 or 9, and that has included, on occasions, police at my door at 2:30 in the morning searching for bombs under my car. There was actually a device exploded in my street. I have been told I was going to be shot by dissident Republicans on my way into work, and given very specific details as to where I was going to be targeted. I've had threats from loyalist paramilitary groups and from a well-armed organised crime gang which has been responsible for 3 murders. Sometimes they'll happen in quick succession. I'll maybe get 2 or 3 in a month, and sometimes you're working on an investigation or story and you can almost sense that when you get to the end of it you will get a death threat because of the nature of what it is you're working on. For me, it's become something that you do have to find a way to live with. It is a job and it is something that I have chosen to do. I try and, I suppose, in my head rationalise it in that I get to go home to my very heavily fortified house at night, whereas the people who I speak to who are often speaking out against paramilitaries don't, and they're the people who I would take my hat off and say show real bravery compared to what I do as a choice. It's something I've chosen to do. During the lockdown period, I suppose it was very difficult. I got 2 very serious threats from a dissident Republican group, a violent sort of armed dissident Republican group, and then quite quickly after that my name was painted on a wall with a threat as well. And all of that, I suppose, if I could just quickly go back to what the previous panel were speaking about, I also have an IPT complaint lodged in relation to surveillance on journalists. The surveillance that I believe that was on me, and I don't mean to keep going back to George Hamilton, the previous Chief Constable, but I do believe quite intensively around that time would have went beyond checking phone records, because the people who I'm dealing with as sources, as you can imagine, aren't that keen on speaking on phones. You know, these people who are people who I'm meeting in certain locations. After Trevor and Barry raised this issue, and several of us and other journalists have lodged these complaints, and I have also made a submission to Angus McCullough. I made my own, obviously, and sort of dealt with my own sources and tried to get to the bottom of maybe how deep it went before I made the complaint, so that I would actually know what I was complaining about, and have been told by a very senior former police source that the intrusion on me went beyond that to intrusive surveillance, and also the use of a covert human intelligence sources to spy on me. So to get a RIPA warrant to spy on a journalist is a very high bar. You can imagine not everyone is going to sign off on that, but to get a warrant to put that kind of intrusive surveillance on someone who might be around me or someone who I might be dealing with is much easier. And the surveillance on me, I believe, went beyond that. Now, how does that put me at risk? Because I do know through solicitors and other people that when some of these people who I might be writing about are arrested, during interview, it has been put to them on occasions that maybe stories that I have done and sources that I have met and where I have met these sources, and then what may have appeared in the paper after that, and that's then put to people in investigation. Now, these are very dangerous people that you're dealing with, and would they think, well, that's a result of maybe, you know, police surveillance, or does that put me under question and put me and my children and my life under threat? Because in Northern Ireland, if it was considered that I was dealing with the police and passing information that I knew on, that could put me at really serious risk. Whereas that is being then said to people in interview, and these are things I know as fact. The problem with the IPT is, as Trevor and Barry pointed out so ably, is it takes such a long time, and they actually don't have to give you a time frame. It could take from now to forever for me to find out the extent of this. I also think that it doesn't go far enough, and that we don't know the role of MI5 in monitoring journalists in Northern Ireland as well. And all of this adds to the threat on me, because I am getting threatened by paramilitary groups, but many of those paramilitary groups also have informers who are working for the police at the same time. So where is the crossover in that, in terms of the surveillance on journalists, the handling of informants, and what that does for the safety of people like myself who work in a very, very specialist area of journalism. At Christmas, I got, I think, 3 in the month of December last year, 3 TM1s. As I said, there's police have been at my house at all hours of the day and night. I'm lucky that I have very understanding employers in Media House who employ me, but the windows of my house are bulletproof. The door of my house is bulletproof. I have cameras. I have alarm systems. I have, GoPros on my car in case anyone interferes with it when I'm sleeping. I mean, these are not the kind of precautions you imagine someone working as a journalist in 2025 should have to take.
Alison, you did say you chose to do this job, and you went...
I do choose to do it, and you would probably say why, but it is actually a very fulfilling and worthwhile job. It didn't sound like it after what I've just said to you, but there is a good part to it as well.
I think, and I think as politicians we understand that the impact of your job has on your family and your friends and your ability also to do your job. What's that impact been on your family, friends, and that ability?
My children are growing up, and I actually had a conversation with one last night that says we have a really unhealthy relationship with fear, because we don't because police would have came to the house and the kids would have said, "What's wrong?" And I went, "It's fine, it's all right, it's a threat, but it's not real, it's just people trying to scare you." And then she's like, "Does that mean that we think that all threats aren't actually real?" They have grown up with it, and so they're now adults, and They take it with a pinch of salt. In fact, they actually call my house Castle Greyskull. There's that much security around it. The impact it has, I have elderly parents and I just don't tell them any of this. You keep a lot of it from people. And at times I like to think that I'm quite tough and I'm not, and a resilient person. But I did the other week, I was sitting in my car, just as you get in, you're plugging your phone in, and I seen a person coming up the inside of me wearing like a high-res vest and a snooter, and I started screaming, and it was the Amazon delivery guy trying to deliver something to me. And he said, "Why are you screaming?" I said, "I thought you were going to shoot me." "Why would I want to shoot you? I'm the Amazon guy." So even though I say these things don't bother me, clearly at the back of my head there is, the thought that at one point this is going to be how I'm going to go, that I'm not going to die of natural causes. The good points that I would, journalism in Northern Ireland, it's a really unique place to work. It's a privilege to be able to do what I do, and it's, in many ways, it's because we're dealing with not just the legacy of the conflict, but many of those paramilitaries have now turned into organised crime gangs, and they're involved in all sorts of other criminality, and there would be, I suppose, not that many of us left that would have come up through that period. So, I have I suppose an area of expertise that can't really be replicated, and I would like to use that to the best of my ability until I, like Malachi, am semi-retired or retired or whatever it is going to happen after that. Maybe I can get normal windows in my house at that point. But, I do think that the PSNI under John Boucher has made a real effort. Actually, prior to that, Barbara Gray, who's now with the Met, had made a real effort in terms of threats to journalists reaching out to us. Previously, if you received a threat, 2 uniformed police officers called your door with a TM1. They might have either give it to you or just read it out to you. It will say, we believe you're going to be shot, sometime in the next 3 days, either at your home or your work or whatever the threat is. You could ask those police officers questions, but they wouldn't be able to answer them because they're literally just handed something and said, go deliver that to that person. And finding out where that threat came from then was really difficult. And in the past, the police were not willing to actually explain to us where that threat would have came from, because it would have been intelligence-led and they wouldn't have wanted to give you that information. Now the PSNI actually have a special department set up which deals specifically with threats to journalists and public figures. So they will contact you, you will actually get a detective, and you will be able to find out, did that threat come through intelligence, or did that threat, was it phoned through to like Crime Stoppers? Now clearly if you're me and you're getting those threats, one that's phoned through to Crime Stoppers, I'm not going to take as seriously as one that comes through intelligence. But then again, you have the issue where police have the intelligence that this journalist is going to be threatened, but they don't act on it, because to act on it would then put their chiz, their informant, at risk, and therefore their safety prioritises mine almost, if you know what I mean. So nobody has ever been arrested or convicted in relation to any of these threats.
Thank you, Leanne.
Thanks very much for giving the evidence today. I want to speak specifically to the threat and intimidation faced by female journalists in particular. Obviously, you've talked a little bit about some of the things that you've experienced. Could you speak more broadly to just the experience of female journalists in particular?
A lot of the abuse that journalists get, I think, is universal. It'll go across the board, but the abuse that I get compared to my male colleagues, it's very gendered. So when we come to the online abuse, and I know that Séamus mentioned the social media companies and their lack of accountability, do we really think that that's going to get any better under the current regime? No. I mean, I've give up on Twitter, X, or whatever you want to call it in terms of monitoring these. It's very specifically gendered. It's always sexual. Or I mean, some of it can just be vulgar abuse about your looks or things like that. But a lot of times it's very sexual. It's very misogynistic. I've noticed actually that element of it has got worse, whereas we've seen the rise of, I suppose, what we'd call the far right in Ireland. So that has put a new element which is very gendered. So you will have groups of people who insist that I am somehow responsible for covering up hordes of people who are coming here and murdering women, and that the figures just don't add up to that. So they'll accuse me of that, and then it'll be, well, I hope that you get raped or your children get raped, and then you'll know all about it for covering all of this up. So that's actually made it worse, and I've noticed that they would probably have been I suppose, barred off most social media platforms, but now that's being allowed. It's now called free speech to say you deserve to be raped. And a lot of that misinformation is being directed very deliberately at journalists to undermine you. That's part of, I suppose, that sort of Trumpification of, call it fake news, say they're all liars, and then even, it doesn't matter what they write, nobody will ever believe it. And so that has changed it, and a lot of that is extremely gendered in the way that it comes to me, and it's dozens and dozens of fake accounts, and I don't even know where most of them are based. I suspect some of them are hordes and hordes of accounts based in America or other places pretending to be based in Ireland, but you can tell sometimes by the language that they're not. But it is very specific to female journalists, and because I suppose what I do would have been in the past considered quite a male job, there wouldn't have been very many female security journalists, so therefore you get that added misogyny of people who can't abide the fact that there is a very mouthy woman doing a job that they don't believe I should be doing.
Thank you very much.
Gavin?
Thanks very much, Chair. Serbia, I think, is where some of the servers are based for the Shinner bots, at least, who do a good job of intimidating others on Twitter. Allison, you mentioned about the team that they've set up in PSNI.
Yeah.
And it's good to see you both here this morning, by the way. And that's given you a greater level of access to information, and therefore potentially, though I don't want to speak for you, more comfort around what was previously unknown, that you have access to that information. Can I ask, are you reassured by the PSNI's approach to these things, or do you find it thoroughly frustrating?
They are generally trying, and I can see that there's a real effort to try and make amends for, I suppose, the way these threats were treated in the past. They were treated like, well, it's part of your job, get on with it. We get threatened, you get threatened, deal with it. But there has been an effort to try and address that. And I think that we all, as journalists and my colleagues I work with who work, especially, I suppose it would be me and maybe the people who work in the Sunday papers would be the ones who receive the most threats, are grateful that you are receiving that. The one thing I will say is, though, I have never received any assistance from either the NIO or anyone else in terms of the amount of money it costs to protect yourself from this. I mean, the amount of security in my house has cost tens of thousands of pounds, and my employer has footed that bill, whereas I imagine had I been, a politician, a police officer, that would have been paid for by the Northern Ireland office, where that isn't accessible to journalists, even though the threat level would be quite similar.
That's extraordinary. I hadn't realised that was all provided for by your employer. Malachi, I know the focus of this has been around female journalists particularly, but you've been a journalist and a writer and a commentator for many years. You've similarly experienced physical abuse and intimidation, and I've heard you speak of it in the past.
Not recently. I mean, I'm not a workaday journalist, or at least a workaday reporter, so I don't have an experience that compares at all with Allison's. I've never received a notification from the police that I was under threat. When the question arose, my immediate thought was, well, this doesn't really happen to me. And then I cast my mind back, and all kinds of incidents come up in memory. I mean, I suppose the most dramatic, but it is going back some years, was when I was at the Felons Club in Belfast to cover a speech by Jerry Kelly, whose name will come up again, I'm sure. And I was taken aside by Bobby Storey, who was a senior member of the IRA, and basically pushed up against a wall and told that I was a slug and a member of MI5, and that I was not to be appearing in the club again. Some friends of mine went to the Storey and others and said, well, what's the big deal with Malachi? And he said, well, he just shouldn't think that he can walk in and out of West Belfast at his leisure,
Just to put that into context, you're talking about somebody for whom there was probably no one more senior in the IRA at the time.
I don't know what his specific role was. I mean, occasionally journalists would get intelligence briefings on who was a member of the Army Council, and his name would not have come up as a member of the Army Council. But I think he was Bobby Storey. He was described as an intelligence officer. I had written a radio talk which had gone out, I think that morning or that week anyway, about the role that Storey was playing in monitoring the Republican movement itself to check that people were on side with the ceasefire. That's how far back it was. And I was referring to his record and saying, is this really the kind of person we want defending the peace process. That was the question. And the funny part of it was that he'd asked for the script through somebody, and I'd sent him the script, and yet he was coming on, the big intelligence officer, I have sources, I've got your script. So there was something. There have been occasions, one of the most awful times was during the Harryville protests in Ballymena, where I was jostled and threatened by loyalists. I was threatened by loyalists at the Billy Wright funeral. He was a major loyalist, and like Allison, though not on the same scale, I think I get quite a lot of abuse on social media, and that's more likely to come, I suppose, because of the commentary rather than the day-to-day reportage. But I get anytime I do anything on social media, I'll get abuse for it. But I think you do have to shrug it off. You can't go to bed every night worrying about some anonymous person who's saying nasty things about you.
Just to close this section off quickly, I think, so we can move on to the legal aspects of it and some of the legal curtailment, or at least the legal protections for us all. Can I just ask either of you briefly, are there recommendations or suggestions that you think the Northern Ireland Executive or this government in Westminster need to take to protect press freedoms, or in spite of all that's been mentioned, do you feel free to do your jobs?
The greatest inhibition I have felt on my work has been the legal threats to take me to court for defamation but that we were going on with that. I think we certainly need to look at Twitter in particular and the toxic stuff there. I would love it if there was a rule that you could not post on social media anonymously, and that would be the end of the matter. That would, because just every day these snide, vindictive and toxic messages from people with pseudonyms, and you have no idea who they are.
Thank you, Alison.
Well, if I was to label you, I would receive a letter, probably from Paul Tweed, saying that I had labelled you and there would be legal repercussions for that. Whereas on social media, people can say anything. And we have also had, I suppose, which is a threat that we haven't even begun to touch on yet, which is AI and what difference that is going to make. We know we have had two, a politician from your own party and one from the SDLP, who've been subject to deepfake porn, which was used to try and discredit them in the run-up to an election. Now that we have, an unknown quantity in X, the amount of damage that can be done to a person's reputation before you even have a chance to defend yourself and say, look, this is fake, this isn't real. The damage is already done at that stage, and so I do think that there was scope to treat them like publishers, and if they don't monitor their activity, then they should be able to be subject to libel proceedings. I understand why people want to be anonymous online, and we have people who live in countries where there are regimes that do not allow free speech, and there's also people who maybe have very strict employment regulations around social media use who just want to have a bit of a laugh on whatever, and I can understand why they'd like to be anonymous, but I do think there's scope as to maybe you have to register with your ID and then you can call yourself whatever you want, but it does mean that at one point in time, if you cross that line into criminality, well then your details are much easier, because I know in cases where there's been criminal activity and threats to me, it's very difficult then to get the IP addresses and from those social media companies, and also if people are so inclined, they know how to hide the IP address as well, or they use open source Wi-Fi.
Thank you, and just to assure you that if you defame me, I will phone you before I get
somebody. Will you contact Paul Tweed? Yeah, you cost too much.
Thank you very much. That's all very disturbing. And now we'll move on to the legal intimidation and coercion tactics that you might have been subject to. Malachi, could you outline the case, the legal action brought against you by Jerry Kelly, MLA, and you might touch on the impact it had on you personally and financially?
Well, Jerry Kelly is a member of the policing board. He's a former member of the IRA. He's proud of his past in the IRA. He's not ashamed of it. He led a mass breakout from the Maze prison in September 1983. During that breakout, a prison officer called John Adams, who was in the control room, was threatened by Kelly that if he didn't behave, he would be shot dead. Kelly was armed. Adams did something. He moved. He tried to close the door. And there are two different accounts of what happened next. One is John Adams' account, which is that Jerry Kelly stepped into the control room, pointed a pistol at him, fired twice, missed once, and hit him above the eye. Didn't kill him. The other version is Jerry Kelly's own account in his book, The Escape, where he says that he and Bobby Story, whom we've heard about already, were outside the control room, noticed that Adams was trying to close the door and rushed the door, and one of them, unnamed, got a shot round the partially open door, and that hit John Adams in the eye. There was confusion of identification in the trial, and Justice Lowry concluded that Kelly may well have been the one who fired the shot, but it wasn't sufficiently sure to convict him on it. He was named as the shooter in the Hennessy report into The Escape, and named in 2 television documentaries that Kelly himself participated in, and has been named as such in several books. Anyway, I was on 2 radio programmes on August 2019 on the same morning, and it just occurred to me in both separate interviews to use Kelly as an example. One of the points I was making was that somebody can have a past, but their present may be different. It was actually saying something almost complimentary about him. I wouldn't go that far, but anyway, it was saying that, we know that he shot a prison officer in the past. We don't expect him to do it again. Things move on. The context changes. In October 2019, then I got a letter from Kelly's solicitors, O'Murray in Belfast, basically alleging that I had defamed their client, Mr. Kelly, and requiring compensation for my defamation of his character. And I thought, I was bewildered. This is a joke. Jerry Kelly had been doing a roadshow with Bobby Story, telling tales about their heroic breakout from the Maze prison. And so I was perplexed by it, but I was also inevitably flummoxed and disturbed and worried. So I did, I didn't immediately laugh it off. I had dealings with my solicitor and with a brief, a barrister. And the initial thought was we might be able to form, make an offer, a form of words that'll maybe, suggested without prejudice that would wrap this up and get rid of it. And but there was no reply to that from Kelly for a year. What he did throughout the whole process, and it lasted 4.5 years from that original letter, was he procrastinated at every stage so that to drag it out. And so no reply came at all from for a whole year. And in that time, I A, thought it had all gone away and he'd wised up, and B, thought, well, hang on a minute, what possible form of words can there be to say that Jerry Kelly, who participated in the bombing of the Old Bailey in London in 1973, who had been in prison for that and who had led an armed escape, what possible words can I come up with to endorse the fine, upstanding reputation of this decent citizen who happens to be a member of the policing board? And there simply wasn't a form of words that I come up with. So I let it drag. I was notified at the end of a year that a writ had been lodged in the High Court against me on the defamation of Jerry Kelly. No one came near me. Again, a whole year went past. And I thought, well, that's it. He's let it go. We're very sensible of him. And then at the end of that year, then a writ was delivered to me at my home. Nice young man with a brown envelope. There you are, Mr. O'Darley. And so that meant I had to reply to it, and I replied to it within 14 days, making out a case with my lawyers. And then nothing. For 8 months, nothing. And then comes a statement of claim. And the statement of claim was ludicrous. I mean, you would not believe it. I was thinking to myself, this man thinks I have damaged his reputation. What's he doing to his own reputation? What's he doing to his own reputation among people in the Republican movement who respect him as a former Republican? When he's saying, in effect, I'm not like the guy who fired that shot. I'm better than him. I have a reputation and he doesn't have a reputation. That was the implication of the position that he was taking. He was making a complete ass of himself. And yet here was this statement of claim with these points that had to be defended. One was a suggestion that Mr. Kelly had been in illegal possession of a weapon. It's in his own book. That Mr. Kelly had used an illegal weapon in a threatening manner against a prison officer. It's in his own book. So again, I sat down with lawyers and I said, look, this is very, very stressful. I mean, they knew how stressful it was, and it was getting more stressful because of the way in which it was being handled, and that you were being lulled into the sense that it was all gone away, and then you're being hit with it again. So, and I regarded that as malicious, you know. And so we had a discussion, and we came up with the idea that essentially we should just apply to have this writ struck out. And that's what we did. There was the genius behind that was a retiring lawyer called Brett Lockhart, a wonderful man, and he and his son worked on this application to have this writ struck out. So a date was set then for the hearing in the High Court in Belfast to have the writ struck out. The date was set, and then on the days before we were to have this, then we get a message that the timing doesn't suit. Okay, well, it didn't really suit my team either, so we're okay, we're happy enough to agree with that. It's put back 6 months. 6 months comes and says, look, there's another case very similar to this against Ruth Dudley Edwards. Why don't we combine the two together and then set a date for further on? So a third date was then set for December the 7th, 2023, 4.5 years after the thing had started. And then when we turned up at the High Court, it was the Master's Court. The Master was Evan Bell. It was a little like an academic scenario, seminar really, you know, dealing with him. My wife was there. She really enjoyed it in that sense. She's more of an academic than I am. But it was it was essentially the two briefs put their case before the Master, and the Master makes a decision on whether or not to allow the defamation to proceed. He came up, I mean, essentially, I've got his words here, he struck the thing out as scandalous, frivolous and vexatious, and an abusive process. Now, this was interesting, an abusive process. What he's saying is that Jerry Kelly isn't doing this at all to preserve a reputation, which has no tenability. What he's doing is he's messing with a bothersome journalist. That was the judge's term. I don't regard myself as bothersome, but it's legal. It's legal. The adjudication has been made that I am bothersome, so I live with it. An abusive process. So a member of the policing board was using the courts to intimidate a journalist or to extract money from a journalist, and and as a member of the policing board, he's supposed to have some kind of regard for the justice system and the legal system and policing. And here he is using the courts in this abusive way, and it is affirmed by the judge that he's using it in an abusive way. So that was very interesting, and it raised the whole. And the judge said that this was a slap case. Now that term had not been used in the courts in Northern Ireland. A slap case being a strategic lawsuit against public participation, the tendency, the ability of people to use the law or an interpretation of the law to restrict public discussion of an issue of concern to them. And as the Kelly case was underway, another one came through, and it was from the Kevin Winter firm, you know. And this was a claim that I had caused emotional distress to a woman that I'd referred to in a television documentary, which I'd reviewed on Facebook. And I spoke to my lawyers about this. Is there any way in which I can be sued for causing emotional distress, much as I might regret having caused emotional distress? And I said, no, there's no legal basis for that at all. Right? So what happened? So I've got another slap case. So my decision on the basis on that advice was simply to ignore it. And I ignored it, and a couple of months later came the follow-up. Since you have not responded to our claim for damages for Mrs. will not name her, we will now initiate proceedings against you. And I ignored that as well, and nothing happened. So what is happening is that lawyers are... The first person to recognise a case as a slap case is the lawyer who's taking it. That is my experience from this. That is the point that I think is most important to make about this. And I think that if we're going to do anything, we need to have a closer monitoring of lawyers and a closer, address to them to say, look, cut it out.
You've painted a picture of not one, but at least two for you cases where
from human rights lawyers, as they call themselves,
in the words of a judge, scandalous and vexatious, and ones that have drawn out for many years, and the impact that has had on you. Do you think we have I mean, you kind of touched on why you think the case might have been brought against you specifically. Do we have a culture of this creating a chill factor? And is this, I'm asking you to speak anecdotally, but is this something you think other journalists are subject to and anxious about in the course of their work?
I think journalists are constantly anxious about it. The problem is we have no way of measuring the scale of it. We have no way. Most defamation cases are settled before they come to court. That means they're not put to any judgment. An awful lot of those cases may have been defensible. But people see, okay, my advice when I went to my lawyers first was, look, you could even win this and end up with £60,000 in costs, right? So, I mean, on that kind of basis, is there a way of buying my way out of this for £10,000? That becomes a very, very attractive option. And that is the option that an awful lot of people are taking. You know, so because of that, we don't have a record of these cases. We don't have any sense of what the scale of this problem is. I think, I'm sure Allison has had letters from solicitors. I'm sure it's a very common experience, and it's a frightening thing, and it puts you in a very, very difficult position. So what we need is some kind of way of registering the scale of these. What we need is some kind of sense of how journalists and people threatened with slap cases can get immediate advice on whether a case is a slap without being put to any expense. And the other thing we need is compensation for people who are harassed in this way. I mean, a taxi driver says to me, what are you going to do with all that money you got out of Jerry Kelly? I didn't get a bean out of Jerry Kelly. I got tinnitus from Jerry Kelly. You know?
I think, as you say, we don't have a handle on the problem, and obviously I'm aware, again, anecdotally, of cases where an employer, a publication, as you say, a bit like a car insurer, you know, settled for the few quid rather than running the risk of expansive court costs. There's loads I would like to get into. I'm going to pause with that for a moment. Mr. Tweed, can I ask you briefly how defamation law in Northern Ireland compares with that in England and Wales, and do you believe that the culture is different?
I don't believe it's different as such. I think the one advantage that Northern Ireland... Can you hear me okay?
Yeah, you're quite poor if you don't mind coming close to the microphone, thanks.
Right, okay. The difference between Northern Ireland and England and Wales at the moment is the cost of defamation proceedings. I mean, over the years, the media in particular have been focused on damages awarded. I was recently cited by a defendant lawyer when they were asked to estimate their costs by the court. We got an estimate of just under £3 million. This was a case been brought by one claimant against several defendants who had one particular firm of solicitors acting for them. Now, Northern Ireland, the costs are nothing like that. I mean, I would say at the outset, I have had nothing but sympathy for Malachi's dilemma, and in fact, I made it clear that there would have been an extremely high cost penalty for the plaintiff who brought this totally ill-advised case in every sense of the word. But Northern Ireland, we have managed to keep the costs down. I act, as I say, in London, Dublin and Belfast, and the costs in London are eye-watering. The costs in Dublin are not, they're catching up, we'll put it that way. And Northern Ireland provided, I mean, the worst thing that's happened to Northern Irish defamation law, plaintiffs and defendants, has been the 2022 Act, which created all these different scenarios. It was a half-cocked affair. I made it absolutely plain whenever it was being debated, the same way whenever I was on the Ministry of Justice panel debating the 2013 Act before it came in. We have got to focus on the real culprits here, who are the social media, the big tech platforms. And we have had opportunity after opportunity to put a simple clause into legislation that the big tech platforms should be treated as publishers, because all the abuse, I mean, I act for many female MPs, MLAs, female journalists, and the misogyny out there is appalling. It's absolutely appalling. But, you know, that cannot be communicated unless it's facilitated by these platforms. And they just say, right, it's nothing to do with us.
I don't think we're going to be in much disagreement about the role of the social media companies and the need to regulate. Malachi has just outlined the personal and financial strain he experienced and the fact that that's unlikely to be something that has just affected him. Do you acknowledge that that exists within the current legal framework and that it can drag out for many, many years, and that people are perfectly able to do that and put a journalist making legitimate comment through that pain and stress within the current legal framework? And do you acknowledge that that is not an acceptable situation?
So far as I'm concerned, I mean, the law, the process of the law is far too slow. It cannot deal with the scenario we're dealing with online actions today. In Malachi's case, I hope it was an exception in terms of what he had to go through. I mean, it really was quite, and I can understand why he's frustrated with the legal advice that was obtained there. But the bottom line is there are two sides to every coin. I personally have been subjected to people following me, my family, my teenagers. I've made a complaint into the UN Special Rapporteur for the independence of judges and lawyers. According to the Sunday Times, there have been numerous attempts to try and hack in to my email system. I get threats, and at the end of the day, nobody's going to have much sympathy for a media lawyer, and I'm not looking for any. I look after myself. But it is a problem that it's not one way. It's not one-sided. There is a problem that you have to look at both sides of the coin. And the difficulty is trying to protect everyone here. We're talking about slaps, and if I may just make a point about the slaps as well. Slaps, there should never be a situation where somebody uses their financial wealth or whatever to try and threaten journalists, lawyers or whatever. But, and if I may clear, if I just finish at one point, I've been subjected to the same people who have been arranging surveillance or whatever. I have also been subjected to a situation where a book was published by a guy called Andreas Craig, and in it he accused me of being a covert agent for the UAE or a stooge. Now that to me is I've been in this business for 5 decades. So I wrote to him, my firm wrote to him, 7 pages. We set out my objections in detail. This book has appeared, on the university databases, the parliamentary databases around the world. It's not, so I could not let it sit. But I said, would you please, because I wrote to you on behalf of a couple of clients, you decided to have a go at me. You decided to have a gratuitous go at me in the book. But look, I just want you to retract and apologise. I'm not looking for any money from you, not looking for costs. And I set out in 7 pages so nobody could complain. He ignored it. I then sent 4 more letters, ignored. He decided to retweet something that was defamatory of me again, took it down very quickly when he realised he couldn't stand over it. But what he did was he made a complaint to the SRA that this was a slap case, that I'd written to him. He doesn't reply to me, does nothing. I mean, unless I got down on my hands and knees and begged him, I couldn't think of what else I could do. Puts a complaint through. The SRA investigated very thoroughly, took up a lot of time. My firm had to go through the whole thing. And they looked through it and they said, they agreed there was no way it was a slap, could not be a slap. The letter set out the detailed basis of my claim. I said it the steps to be taken to avoid litigation. I just asked simply for the paragraph to be removed and an apology. It did not contain language that was unduly aggressive or intimidating, and there was no indication that my firm was attempting to exploit a vulnerable party. So that's the other side of the coin, and that's, I say, not for one moment taken away from Malachi's situation. I think it was appalling. Yeah. But if you're talking about legislating for slaps, you've got to look at it for both sides.
Crucially, and I think all of us would defend people's right to a good name. And may I say, I'm so sorry to hear about the experience of you and your family. Nobody should face intimidation in the course of their work. And you've said that cases like Malachi's should not happen, but they clearly do, and they happen extensively. The judge, as Malachi read out there, said that it bears the hallmarks of a slap and was initiated not for the purpose of vindicating reputation, and I think we all agree that's legitimate, but rather for the purpose of stifling the voices of troublesome critics. Have you ever initiated proceedings that you think could be identified in that way on behalf of a client?
No, I don't believe I have. On the contrary, I mean, I'm absolutely fine because I act for publishers and newspapers as well, so I have to keep swapping my hat around. Sometimes I do get confused, but the bottom line on it is that should never happen. It's appalling that it happens.
And do you think that Malachi's is a one-off? Do you think Malachi's is the exception or part of a culture?
Well, I'm not aware. The Putin's people, the author of the book Putin's People here in England, was, I understand, subjected to one. I was not involved in any of these cases. I'm not aware of other scenarios. I have, over the years, people have said, they've accused me of being a lawyer who's feared, which is absolute nonsense in my opinion. I'm right. Whether I'm defending a female journalist or I'm coming, trying to protect a newspaper, which I think wrong. I do what I do. I'm taught to do, and I've all the experience to do, but I do it as proportionately, fairly, and appropriately as possible, and that's the way it should be done. This was obviously not the case in Malachi's situation, and I hope that this is not repeated elsewhere. But I can't. I obviously don't.
You think that Malachi's appears to be the exception. You don't think that that's part of an
I don't know.
culture?
I don't know. That's the only one I know about myself.
Okay.
So I mean,
obviously the definition and categorisation of slaps is evolving. Are you familiar with the concept of super injunctions, and do you think that they would fall under the same categorisation?
I don't believe there have been any super injunctions for many years. It's the same as libel tourism. I've been accused of. I'm still waiting for somebody to give me one example of libel tourism. Slaps are falling into a similar category. That people are using it as a basis to demand reform. All I would say to people, and I mean, I'm at a stage in my career, it doesn't matter to me, but once you start codifying, or trying to codify the common law, legal costs start going through the roof. And I do not want to see a situation in Northern Ireland where the prospect of protecting your reputation in any way at all is going to become beyond the means of the ordinary person in the street.
But of course it is, and in many cases there is a complete inequality of arms in that the costs can tick up as they did for somebody like Malachi. In that case, imperfect though it was, there was at least a two-sided legal process where he would have had, if he had the unlimited financial means, the opportunity to go in and ultimately be vindicated. Are you aware of legal proceedings where that isn't the case, where reporting or mention of an issue that may be in the public interest is, I suppose, suppressed by legal threat or by legal injunction?
Well, we like to protect our clients as best we can within the regulatory and financial constraints are there. I can't go into specific cases, obviously, for client confidentiality, but I fight for my clients within whatever financial means they've got. I do everything I possibly can. Unfortunately, defamation law is excluded from the legal aid system, so you cannot get legal aid for defamation. And in Northern Ireland, we're quite unique as well, that it's against the Law Society rules for a solicitor to do a no-win, no-fee, unlike in the Republic of Ireland and in certain circumstances in England and Wales. So that's something that should be looked at. I've been urging somebody to look at it. You won't do the legal aid, at least give the lawyers as much flexibility as possible. I mean, I'm in a lucky position. I can pick and choose my cases. I'm certainly not looking for work, so please don't call Paul. But I will fight to the death for my client, and it doesn't matter whether it's a journalist, a newspaper, or somebody who has faced public opprobrium or whatever. I'll decide on the merits of the case, and then I will fight, and I have the backbone to do it. My big concern here is, while we're debating these issues, the big problem that's coming in now is AI. Generative AI is going to make a lot of our debate today absolutely meaningless. Totally lost. If I could give you one example, and this is for Malachi and Allison.
And the generative AI, and I'm going to just, the time isn't in our favour here, and I know colleagues do want to come in, including on that legal framework that currently exists. We're not necessarily in disagreement on AI, but I don't think time allows. Thank you.
No, could I just make one point on AI, if I may? And this is just more, I'm not in the same league as Malachi or Allison.
We've identified really substantial, I believe, gaps and flaws in the legislative framework that we have relating to defamation and slaps in Northern Ireland, and I think we could eat up all our time on AI.
AI is far more important, Claire, than anything you have been discussing today, in my opinion. But as I say, it's up to you. If you're going to try and cut me off and silence me here, that's up to you.
I'm going to give you an opportunity, Paul, to tell us what you wanted to tell us about AI. Could you put it in writing, please?
Perfect. Yep. So.
Could you put it in writing, because we do have an interest in AI on this committee, so it would be really useful if you could put that into writing, and we'll follow it up, because that is something that we may be looking at. Is that okay? Thank you.
I'll do that, but as I say, it's a question of priorities.
Okay, Gavin Robinson.
Yeah, thanks very much, Chair. And Paul, I'm coming back to you, so no way but you'll respect the nature of the inquiry we have today, which is about slaps and potentially what recommendations we could make about slaps. I think just a couple of simple questions. It is possible to pursue and protect your reputation in Northern Ireland without recourse to the High Court. People can do it in a much more cost accessible way in the County Court, isn't that correct?
That's correct, although it is rarely used, I would have to say, fortunately or unfortunately, for a number of reasons. But I think, very few cases actually reach litigation. I mean, Northern Ireland, defamation is not a problem in Northern Ireland. I mean, I would be bankrupt if I depended on, litigation, the defamation litigation in Northern Ireland. It's just there's very few cases, and as I say, the cost, it's a good thing, are low by comparison to the other jurisdictions that I operate in.
Yeah, second question.
Sorry, Gavin.
Yeah, sorry. So we can do it more cheaply in the County Court, that's accepted. Yeah. Second question, you as a professional will be approached by many who say, I have this issue, can you give me advice? And you will say that's a no-hoper, or you'll say that's a case worth pursuing.
Absolutely.
Is there sufficient action from the Law Society to go against those professionals who do not give proper advice? If a lawyer is proceeding with a case which is ultimately vexatious, what sanction is there? And should there be a sanction?
There is sanction. All three law societies that control or regulate my work, and I've got to, we've got to make sure that we comply with all the regulations. But if a complaint is made, now, for instance, Malachi, is free to make the complaint if he hasn't already done so to the Incorporated Law Society of Northern Ireland on the basis of the conduct if he feels it has been appropriate, and that would be an option. And I would like to think that action would be taken. We are very, very carefully monitored, and certainly if I step out of line in any way at all, I would expect one or all of the law societies to come down like a ton of bricks on me. So there is a regulatory sanction there that each of the law societies have. The SRA are probably the strongest one in London here, but there are sanctions available to all three law societies.
Thank you. And then third question finally. Small claims court, there are no costs. It's an informal process and you can't have a cost award against you, save for vexatious cases where a cost award can be made. Malachi's outlined a situation where he had a case struck out and appropriately used that mechanism, but it took 4.5 years. Should there be a move where a case has been brought and it's a total no-hoper and it's been used strategically to shut someone down and it's going nowhere, it is in all legal parlance vexatious, should there be compensation for the person who was subject to that slap?
Well, there should be two factors there. First of all, there should be an ability to bring a case before a court much earlier and much quicker, and that would have obviously removed a lot of the stress that Malachi will have been under for several years, and I think that's something that unfortunately the court system can only handle so much in all the jurisdictions that I would work in. So the answer is yes. If you're saying then should the sanction be on the person that brings the case as a financial sanction or on the lawyers that advised them, at the end of the day, I certainly wouldn't be averse to that. If that's something that could be implemented, the answer is yes. And provided it's two-way, because as I say, I've given you my example, and as I say, don't expect any sympathy from anybody, but there's got to be fairness, and it's got to be right across the public interest here. But and as I say, so if somebody then makes a wrong accusation about a case being a slap, they should be subjected to the same financial penalties. But I would be all for that. I have no problem with that.
Thank you very much. Thanks, Chair.
I'll bring Malachi in there.
I just wanted to come back and correct you, Gavin, because you referred to the small claims court. It wasn't the small claims court that we took our application to.
There's no need for correction. It's a different point.
Okay, fair enough.
No, you were before Master Bell, the Master of the High Court. I understand that entirely. But it's the cost implication in the small claims court was the point I was making, that there are no cost awards, save for a case is vexatious. And I'm saying, do we need a system in our courts that go beyond cost implications to a compensatory element for somebody like you who is going to, that's a different point.
Thank you very much for that. The other point just about the case that we had, because it was the Masters Court, establishes a degree of precedence, but it's not a precedent that binds the High Court. Would I be right? The more senior judges, and therefore that would be one of the arguments that we would put forward for the need for a clear law on slaps.
Allison?
Could I just add, in my line of work, obviously I'm dealing with people who would have no reputation and wouldn't be able to take a defamation case in the majority of cases, but what they are doing is increasingly taking privacy cases, and there is legal aid for privacy. So the cost to the newspaper for that, with people who might have, in one case, one of the people who took a privacy case had 145 previous convictions. In another case, there are people who will not name but are household names in terms of their activity during the conflict in Northern Ireland, and they have ongoing privacy cases for which they will get legal aid and they could run forever, and there's no way then of claiming those costs back afterwards because it's not a defamation case. So even if they lose, the money that the newspaper has accrued to defend that can't be retrieved.
Thank you. Katrina Murray.
Yeah, I think that takes us quite neatly on, and I am being absolutely honest with you all. I'm used to another jurisdiction. I'm used to the Scottish law, right, which in this area is very, very different. So, looking at the Northern Ireland Department of Finance Defamation Act and the review that's taking place, suggesting introducing a mechanism where a defendant can have a claim held until it's been assessed as a possible slap. Looking particularly to Paul first, what do you think of that proposal?
Yeah, I have no objection to that at all. I mean, I have no problem with any practical steps that are taken to remove the threat of slaps in the background. And yes, I think that sounds to me like an eminently sensible situation. The question is, of course, what is a slap? And is this a slap? You know, people think you have to get a letter from a lawyer now that this is threatening me. I feel intimidated. You know, at the end of the day, there has to be some form of balance, and the difficulty is striking that balance and assessing it. But I do say, just an answer to Malachi's earlier point as well. I mean, the courts, I believe, are well equipped, under the common law, to deal with slaps. They always have been, and in my experience, limited experience where I've come across a slap, they've dealt with it effectively. But I think your suggestion definitely is worth considering.
How do you feel about that, Malachi?
Well, I can see problems in it both ways. I mean, in one sense, if you're going to have another layer of activity in the courts preceding a full case, then that's more work for lawyers and more expense. I suppose that's the danger in it. But I do think we need legislation on slaps, and I do think that where this case is gratuitously an attack on an individual, then that individual should be awarded compensation for that attack. I mean, when Jerry Kelly came at me, if he had been concerned about his reputation, the sensible thing to do was to sue the broadcaster, because the broadcaster had both the platform on which to broadcast a retraction and had the deep pockets to pay the money that was due. One of the clear warning signs that this was a slap was that he had gone for me personally, who didn't have the platform to present a retraction and didn't have the deep pockets to pay him the big money that he would be hoping for.
And particularly within an industry which is becoming much more freelance based, where you do not have the necessarily the protection of an employer that's...
On the legislation, the Council of Europe has put out a directive to member states to initiate SLAP legislation. I think the deadline for that is 2027. Index and censorship was very helpful to me and brought me out to Strasbourg to meet the people who were involved in that campaigning, and an organisation called Reporters Respond was very good and actually donated towards legal fees. So there is a widespread campaign across Europe to deal with slap cases, and for Northern Ireland to be outside that I take Paul's point about, he doesn't know of a case of libel tourism, but if we open a gap between Northern Ireland and the rest of the legislative framework in the rest of Europe, then we're making Northern Ireland a much more attractive place in which to take slap cases, and I think we have to be on our guard against that.
Yes.
Can I just ask two quick follow-ups? There mightn't be, you haven't to name a case of libel tourism, but do you think the potential is there, Paul, for that to exist? Is that a marketable opportunity?
Well, put it this way, people have been saying this to me for the last 20 years and it still hasn't happened. So that's all I can say to that. Okay. So who knows? But I mean, it's not, you know, and also the 2022 Act did make a specific provision in relation to suitability of jurisdictions. So, you know, that's all covered. But like as I say, I'm still waiting to get this example from any of the jurisdictions I operate in. But again, you know, I think we should be focusing on the problems. You won't let me discuss the AI issue, which I think is a major one, which is going to absolutely take over all the legislation you're talking about. So
we'd be genuinely delighted to, but we are bound to stick to the topic, and the chair has invited and will be really keen to read that analysis. I just wanted to pick up on that privacy issue in the PSO. The way of trying to shut the press up. Yeah. It is a way that both shuts the press up and is publicly funded to do so, and do any of the remedies that we've discussed here, are they anything that would help to address that, or are there other avenues that you think should be explored?
No, I mean, the thing about the privacy cases is you do have to defend them. There's no way, even if you lose a libel case, obviously you have to pay the other person's cost. That doesn't happen. You know, I've had cases where I have had to go along to court, the privacy case has been thrown out, but it might have took 2 years to get to that point, and it's cost an extreme amount of money at a time when newspapers are running unlimited resources. And that's the thing that solicitors are advising people who come to them. And I mean, I don't mean I work very closely with some very good solicitors, but if you have someone who has that kind of a criminal record, they're good for your business over a long period of time. And if they come and say, I want to sue that journalist, and you break the news to them, you don't have a reputation, mate, you can't sue anyone, but you go, I've got a good idea, let's take a privacy case against them, and then that appeases them. They get their day in court. Now, I don't know if any of these cases have been paid out, but I'm currently involved in 2 pending privacy cases, and afterwards I will tell you who the 2 people are, and you will be shocked that these people feel that they have any kind of legal case, but they have been going on for quite some time.
I can't wait. We'll wrap this up.
I'm just about to say, the only further question was, but how would any anti-SLAPP legislation sit alongside the existing Defamation Northern Ireland Act?
I think that probably that there is scope for some adjustments to that, I think, to try and make it. I mean, in Malachi's case and any other case that I've been involved in, early resolution is the answer to all these things. That's when it costs less money for everyone, less time, less trauma, less stress. Our courts are just too slow, and if there was a way of speeding that up, I think that would bring these things to a resolution much quicker.
I agree with that.
I just like to say, Malachi, we are part of the Council of Europe, so we will have a look at the SLAPP's recommendations there as well. So I'd like to call this session to an end. Thank you, Paul. Thank you, Malachi. Thank you, Allison. Order.